So let's begin with question number 31. It is asking about the stages of constitutional amendment bill, which requires the state's ratification. Before going to the question, I think we need to know about constitutional amendment bill. It is introduced under Article 368 of Constitution, and coming to specifically the one which is requiring the state's ratification, or else normal constitutional amendment bill. It can be introduced either in Lok Sabha or Rajya Sabha. Here both have equal power. And one thing we need to know is it doesn't need prior permission or approval of President of India, because it is done or given in such a manner because to ensure separation of power between legislature and executive. As we know that president is majorly advised by council of ministers, so to avoid conflict between legislators and the executives, such kind of arrangement is made. Coming back to the question, the first step will be always the introduction of the bill. Next, it will be passing of the bill by both Lok Sabha and Rajya Sabha separately with two-third majority, and provision under Article 108 is not available here. 108 gives about the combined sitting uh, uh, to ensure that the deadlock is removed. So that provision is not available for constitutional amendment bill. And after passing by the both houses, it goes to the states for ratification. After that, as usual, we will be having the assent of the president. And one more thing here is the president cannot deny to assent. It is one of the main point that we need to remember. So after all this, we arrive at option D. Let's check it. That's right. Now let's move on to question number 32. Here it has given some features and some source countries. Fundamental rights, yes, we all know, have been taken from US. Then US Bill of Rights, and the parliamentary system of government, absolutely the Britain. Then directive principles of state policy, that has been taken or inspired by Ireland. Residuary power with center. They are saying its source country is US, but that's not true because it has been taken from Canada. So this is wrong, and we arrive at only 3. Question number 33. They have given 3 statements here. The first is a statement, and 2 and 3 we should analyze them and arrive at answer. Statement 1 says that there are situations in which president can act on his own discretion. It's a proper statement. Then statement 2 says that when no party has a clear majority, president can use discretion in appointing the PM. As in many conditions in in our Indian history after independence, we have seen a few instances of this. Statement 3 says that the president has absolute discretion to dismiss council of ministers that enjoys confidence of Lok Sabha. See, one thing we need to be cautious about is these kind of absolute words, these kinds of extreme words. We should focus on these. And coming to the literal meaning of this option, president cannot dismiss council of ministers that uh, enjoy the confidence of Lok Sabha if the prime minister wishes to dissolve the Lok Sabha before completion of the term. Then he can advise the president, and the president may do so. But in this option, only 2 is correct, and it is explaining option 1. So it is option C. Yes. Coming to question number 34. Consider the following rights judicially read into Article 21, right to life and personal liberty, right to privacy. Yes. If, we got this through Justice KAS Prelims case of 2017. And right to clean environment. Outside the Supreme Court has uh, considered it right in various cases like MC Mehta and all. Right to legal aid. This has been considered to Khatun case. There's a case called Khatun case. Through that, it has been considered. And right to property. Now, right to property was actually removed from it was a fundamental right, and it was removed by 44th Constitutional Amendment Act 1978, and it was moved to Article 300A, which is now just a constitutional right or a legal right and not part of 21. So option 3. Coming to 35th, which one of the following best describes basic structure doctrine? Basic structure doctrine was established to Keshwanand Bharati case in 1973. So here it is asking the best description for that. Parliament cannot amend constitution at all. No, that's wrong. We have amended it 106 times. So that's not a correct option. Parliament can amend the constitution but cannot alter or destroy its basic features. Okay, let's consider it. Parliament can amend any part of constitution, including its basic features. It's absolutely wrong. Only the judiciary can amend the basic features of constitution. While judiciary do has some role in defining the basic structure doctrine, but it is not only the judiciary that can amend it. So we arrive at option B. Coming to the 36th, the doctrine of colorable legislation is invoked to examine option A, whether a law is morally acceptable to the society. Okay. Whether a legislature has done indirectly what it cannot do directly, it is transgressed its legislative competence under guise of apparent legality. Third option says whether a law has been published in official gazette. This cannot be true. Whether a law violates fundamental rights. This doesn't need colorable legislation. It needs uh, doctrine of eclipse and doctrine of severability. So these both are wrong. Whether a law is morally acceptable to the society, I don't think it can be correct. Coming to the second option, whether a legislature has done indirectly what it cannot do directly. So it basically defines doctrine of colorable legislation. If to understand it clearly, one thing we need to know is that this doctrine of colorable legislation rests on a quote which says that what cannot be done directly is done indirectly, and it shouldn't be done indirectly also. In the sense, the court looks at the substance of the law. If there is a law, there is a substance, there are rules. The court not only looks at the rules, but it does emphasis on the subject as well. So in that case, colorable legislation is option B. Moving on to 37, the doctrine of pith and substance is applied by the courts primarily to struck down any law that incidentally encroaches upon another legislature's field if its true nature falls within its own competence. Okay. Determine whether a law is prospective or retrospective. It doesn't do this. Decide the seniority of judges. No, irrelevant statement. Uphold a law whose true nature and character falls within the legislature competence, even if it incidentally encroaches upon another's field. ಸೊ ಇದನ್ನು ನಾವು ಬೇಸಿಕಲಿ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕಂದ್ರೆ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಪಿತ್ ಆ್ಯಂಡ್ ಸಬ್ಸ್ಟೆನ್ಸ್ ಅಂದ್ರೆ ಆ್ಯಕ್ಚುಲ್ ಆಗಿ ವಾಟ್ಸ್ ದ ಟ್ರೂ ನೇಚರ್ what's the true nature and character of the law ಅಂತ. What does the law want to signify, ಅದರ ಗೋಲ್ ಏನು, ಅದರ ಅಪ್ರೋಚ್ ಏನು, ವಾಟ್ ಇಟ್ ಆ್ಯಕ್ಚುಲಿ ವಾಂಟ್ಸ್ ಟು ಡೂ, ಅದು ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಪಿತ್ ಆ್ಯಂಡ್ ಸಬ್ಜೆಕ್ಟ್. ಅದರ ಎಸೆನ್ಷಿಯಾಲಿಟಿ, ಕ್ಯಾರೆಕ್ಟರ್ ಏನು. ಈಗ ಆಪ್ಷನ್ ಡಿ ಇವೆರಡರಲ್ಲಿ ನಮಗೆ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ ಆ್ಯಕ್ಚುಲಿ. Strike down any law that incidentally approaches another legislature field if its true nature fall within its own competence. Simple, they have interchanged the words here. The actual truth statement is D because it says that uphold a law whose true nature and character falls within the legislature's competence even if incidentally encroaches another field. ಇದನ್ನ ಸಿಂಪಲ್ ಆಗಿ ತಿಳ್ಕೊಬೇಕಂದ್ರೆ, ಈಗ ಒಂದು ಲೆಜಿಸ್ಲೇಚರ್ ಇದೆ, ಅದರ ಕಾಂಪಿಟೆನ್ಸ್ನಾಗ ಒಂದು ಲಾ ಮಾಡಾಕ್ತದೆ. ಸೇ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ವಿ ಹ್ಯಾವ್ ಸ್ಟೇಟ್ ಲಿಸ್ಟ್ ಆ್ಯಂಡ್ ಸೆಂಟ್ರಲ್ ಲಿಸ್ಟ್. ಈ ಸ್ಟೇಟ್ ಲಿಸ್ಟ್ನಾಗ ಒಂದು ಸಬ್ಜೆಕ್ಟ್, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಲೆಟ್ಸ್ ಸೇ ಕೋಆಪ್ರೇಟಿವ್ಸ್. ಈ ಕೋಆಪ್ರೇಟಿವ್ಸ್ನಾಗ ಯೂನಿಯನ್ ಲಾ ಮಾಡ್ಬೋದು, ಬಟ್ ಇಟ್ ಕ್ಯಾನ್ ನಾಟ್ ಡೂ ಲಾಸ್ ಆನ್ ಸೋಲಿ ಬೇಸ್ಡ್ ಆನ್ the cooperatives that are operating in the state, but it can do for the cooperatives which are operating in between the states or for the both states. ಇಲ್ಲಿ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಸೆವರಬಿಲಿಟಿ ಯೂಸ್ ಮಾಡ್ಕೊಂಡು the Supreme Court said that you cannot legislate on state list unless the states have asked for, and it struck down some parts, or it stayed some aspects on that, and only allowed for the multi-state cooperatives. So based on these all understanding, we will arrive at option D. Basically, we need to understand that even if the law is encroaching another legislature's field, if it holds a valid reason or valid argument or valid value that can bring positive changes and that can help in growth of the nation, then the court allows such kind of laws even if it is exceeding its competence, legislative competence. Hence we arrive at option D. Coming to question number 38, consider the following directive principles. First one says organization of village panchayat. Yes, that's right. And first let's read the question. How many of the following are classified as Gandhian? Okay, we know that DPSPs can be segregated into majorly 3: Gandhian, socialist, and third one is liberal principles. So organization of village panchayat, article 40, it will come under Gandhian, that's right. And promotion of cottage industries as well, 1 and 2 are right. Promotion of international peace and security, I think it's not Gandhian, because Gandhi didn't emphasize that much on international peace. I think Rabindranath Tagore fits here more, but in context of the question, this is wrong. Prohibition of intoxicating drinks. Yes, as you know that he even asked the tribal people, and some of them had literally quit these kind of injurious activities. So it's only option 3. Yes, that's right. Let's move on to question number 39. The doctrine of colorable legislation. See, in past 4 or 5 questions, we came across many doctrines. Doctrine of severability, doctrine of eclipse, doctrine of pith and substance, doctrine of colorable legislations. I think we need to read about this, not as a whole, but they will help us both in GS2 for mains paper, then prelims through Made Martada, then we can quote if any in ethics and all, we can use them. So coming back to the question, doctrine of colorable legislation is best described as a rule that strikes down a law that is morally unacceptable to the society. Okay, a law that has not been published in the official gazette. This can't be the case. A law that operates retrospectively. They don't need colorable legislation for this, so it's wrong. A law by which a legislature does indirectly that it cannot do directly. Again, the same thing which we had seen here. I think the question is repeated. Sorry for the repetition. Next, let's move on to question number 40. Consider the following statements about 2024 judgment on Property Owners Association versus State of Maharashtra. This is one of the important case where the Supreme Court judged or heard the case. It is basically related to considering private property as public resource for the larger public good. So it's the basic context of the case. Now let's read the option. A 9-judge bench held that not every privately owned property qualifies as a material resource of community under Article 39B. We know that 39B and 39C are the socialist principles which for emphasis on creating a equitable society by not allowing the concentration of resources in few hands and all. So the bench unanimously held that 31C, to the extent upheld in Keshavananda Bharati, continues to survive. Yes, I think these both are right. About Article 31C, the judges upheld basically the decision given in Keshavananda Bharati case. And third, the court endorsed Justice Krishna Iyer's earlier view that all private property can be treated as commodity. See, it also violates the basic rights of the people, because they have earned it through their hard work. If suddenly a state comes and wants the private property to be distributed among the people, surely people will not be okay with that, and even the court doesn't consider it right, so it is wrong. Article 39B is a DPSP. That's right, we know that it's a DPSP. So we arrive at option 3. Okay, now let's move on to question number 41. Which one of the following statements about president's executive role is correct? President may act on personal discretion in day-to-day administration. No, because he majorly acts on aid and advice of Council of Ministers. The Prime Minister must obtain President's approval for every policy. Not necessary. The President can dismiss a Council of Ministers that enjoys majority support. No, here the statement is not clear about the circumstances, so it is not true entirely. The real executive power is exercised by Council of Ministers, and President acts normally on their advice. Oh, that's true. We read it in their act as well. Question number 42. In the Chandigarh mayor election case 2024, the Supreme Court set aside the result and declared the losing candidate elected. Which constitutional power did they invoke to do the complete justice? We all know that Article 142 gives the power for Supreme Court to go beyond their superintendence and ensure complete justice. So it's a direct question. No, nothing more to discuss here. It's Article 142. Consider the following. If which of the following is correct regarding reorganization of states under the Constitution? Okay. Basically, it is talking about Article 2 to 4, where 2 to 4, fourth article gives protection for reorganization of states, and but doesn't give to that of altering or exchanging the enclaves with the neighboring countries, uh, which we saw with that of Bangladesh and India in 2014. In 2015, through the Constitutional Amendment Act, they had to adjust or exchange the enclaves. Leaving that, let's come to the question. A reorganization bill needs prior president recommendation and may be introduced in either of the states. Yes, that's correct. The reorganization bill do need the president's recommendation. A new state can be created only with the consent of the legislature. It hardly matters. The president sends the letter for the consent of the states, and usually the time period of 30 days is given. But even if the states don't want it, the deny it, the advice of state or the consent of the state hardly matters. The parliament can continue to what it does, so it's wrong. Reorganization of state requires constitutional amendment under Article 338. No, that's exactly where Article 4 comes in. It gives protection for the state rearrangement, where it doesn't need and it shouldn't be considered constitutional amendment under Article 368. So it's wrong. Parliament cannot alter state boundaries without a referendum in that state. That's wrong. Option A is right. Coming to question 44. Consider the following statements regarding joint sitting. Joint sitting 108, Article 108. It is summoned by President. Correct. It is presided over by a Speaker of Lok Sabha. That's right. It can be held for money bill that the Rajya Sabha has not passed. Okay. The quorum is 1/10 of the total members of the total number of members of both houses. Okay. Coming to Article 108, the joint sitting can be done for ordinary bills. It cannot be done for money bill, constitutional amendment bill. This is the basic information about Article 108. So, option 3 is wrong. 1, 2, and 4 is the right one. Coming to joint sitting again, till date from our independence, we have celebrated 88th Independence Day this year. I think only 3 times we have had the joint sittings. I don't clearly remember the act, but one of them is Dowry Prevention Act, and other two I don't even remember. So let's move on with question number 45. Article 32 itself is a fundamental right. Yes, we know that. Fundamental right would be the little value if there is no granted remedy to enforce it. This is the exact words of Dr. B.R. Ambedkar in a debate in the Constitutional Assembly when he was asked, why do you give Article 32 as a fundamental right itself? I think this is the perfect reasoning for this. So you arrive at option 1. Let's move on to question number 46. Here they are given article, the right, and to whom it is available. Article 14, equality before law. Before that, let me give you a simple remembering trick. The articles which are or the rights which are only available to citizens, they are 15, 16, 19, 29, and 30. These 5 are the articles which are available to the citizens only. Now let's look at uh, the options. 14 citizens only, that's wrong. Article 19 to all persons, it is wrong. Article 29 all persons, wrong. Article 25 all persons, it is right. So option only 1 is correct, because only 15, 16, 19, 29 and 30 are available to citizens. Yes, that's right. Okay, let's move on to question 47. They have given acts under British rule and the key features introduced. First, to say the Regulating Act of 1773, first step towards central administration. Yes, because Governor of Bengal was made Governor General of Bengal, and the both Madras and Bombay were made governors were subordinate to him. Then it's correct. Government of India Act 1858, rule transfer from company to crown. Yes, that's right. Uh, then Council Acts of 1909, separate electorate for Muslims. This was one of the main controversies and one of the main highlighting feature of this act, and this was the main issue of contention between the extremist leaders and the moderate leaders. Coming to Government of India Act 1919, provincial autonomy. No, actually, provincial diarchy was introduced in 1919, and later on in 1935, provincial autonomy was uh, introduced. The 1935 Act has provisions for provincial autonomy, so it is wrong. We are at option 3 only. Uh, Moving on to question 48. The principle of collective responsibility of Council of Ministers means that, so collective responsibility is reflected in Article 75, clause 3. Each minister is individually responsible to President. No, the Council of Ministers is collectively responsible to Rajya Sabha. No, because they are elected body and they are responsible to Lok Sabha only. Ministers are responsible only to Prime Minister. No, they are actually responsible to Lok Sabha. So we are at option D. Okay, let's move on to question number 49. Statement 1 says that directive principle of state policy cannot be enforced by court. It's absolutely correct statement. DPSPs are fundamental in governance of the country and it's duty of the state to apply them in making laws. Okay, both statements are right, but is it really explaining the statement 1? I don't think so. If it had said that the constitution hadn't given provision for the courts to impose this or enforce this, and they are just guiding principle for the state to make laws that can help in betterment of citizens and bring equality in the society. So option B is the right answer. Consider the following statements about passage of ordinary bill. Okay, we are talking about ordinary bill. It can be introduced in either house of the parliament. That's absolutely correct. Only in case of money bill and financial bill type 1, we can introduce it in Lok Sabha. A deadlock between two houses can be resolved through joint sitting. Yes, both the statements are correct. The president may withhold assent, give assent, or return a bill for consideration. Yes, that's absolutely correct. The Rajya Sabha can detain the ordinary bill for maximum of 14 days. No, it's actually wrong. The 14 days is given under money bill, and even if the Rajya Sabha doesn't approve money bill within 14 days, then it is deemed to be passed only in case of money bill. So option 4 is wrong, hence we arrive at option A. Moving on to the next question. Which of the following correctly describes the nature of fundamental duties? Fundamental duties were added by 42nd Constitutional Amendment Act 1976. Initially, they were only 10, and through 63rd Constitutional Amendment Act. We added the 11th one of related to right to education. The court can punish the citizens directly. No. They override fundamental rights in case of conflict. No. They apply to the states, not to the citizens. No, they were actually made for the citizens. They are non-justiciable, but the parliament may provide for the enforcement by law. This is actually correct. One of the fundamental duties says that respecting and honoring the national emblem and national symbols, and we do have an act for this. It is called honoring uh, the act, say the honors of national symbols and something like that. We have a law for that. So I think option D is the right answer. Well, moving on to next question. Which of the best idea reflects constitutionalism? Constitutionalism is the term that is not defined in the constitution, and it is the term that has evolved through various case laws, various interpretations of various scholars and all. Constitutionalism basically means limiting the government in accordance to the constitution and rule of law, and not giving them chance to act on their malified intentions and dilute the aspirations of the constitution. So it's option D. Moving on to the question number 53. Judges of the Supreme Court are appointed by President. Okay. The Constitution explicitly provides for collegium system. No, again we have to be careful of the extreme words here. The Constitution doesn't explicitly provide for collegium system. Basically, this has evolved from first judge cases to second judge's case and then third judge's case. Basically, the second judge's case uh, gave for CJ plus two senior most judges. Actually, it is from here where the collegium has actually started. It's the innovation of judiciary. So this is not correct. We are at option C. Yes, that's right. Moving on to question number 55. Statement 1 says that the president is bound to act in accordance with advice of Council of Ministers. Yes, that's correct. He is bound to act on the advice of Council of Ministers. Moving on to question number statement 2, the president can return the advice once for consideration but must act according to the advance tendered after that reconsideration. Yes, the both statements are correct, but this is not clearly explaining the statement 1, because the bound to act on the advice, it is under Article 74, which has been amended by two times, the 42nd as well as the 44th Constitutional Amendment, where it made compulsory for the president to act on the advice, whereas 44th added the clause that he can return the advice for once for reconsideration, but if the say Council of Ministers again tender the same advice, then he must accept that advice. So we arrive at option B. Moving on to question number 56. Basically, it is the simplest question, asking the schedule and what it is related to. Fourth schedule, allocation of seats to Rajya Sabha. That's correct. Eighth schedule, languages. That's right. 10th schedule, firm and oath, and also it's actually schedule 3 of the constitution. 11th schedule is about the municipalities. No, that's wrong. 11th schedule is about the panchayat, and schedule 12 is about municipalities, which is 74th Constitutional Amendment Act 1985. Only 2 is the right option. Yes. Question number 57. Consider the following which has been judicially recognized as a part of basic structure. Okay. Judicial review. Yes, this is indeed a part of basic structure which has been recognized by the judiciary. Free and fair elections. Absolutely. Not only basic structure, it is even basic for the democracy as well. Federal character of the constitution. Correct. Right to property. Again, it's wrong. 1, 2, and 3 is the right option. Consider the following statements about Supreme Court. Okay, its advisory opinion in Article 143 is binding. No, Constitution nowhere says that advice under 143 is binding. It's just an opinion. The law placed in 9th schedule after 24th April 1973 can be tested against basic structure. So 24th April 1973 is basically Keshavanand Bharati case, after which the Supreme Court established basic structure doctrine, and it held that 9th schedule violates the principles of constitution because the laws placed in the ninth schedule weren't allowed uh, by the judiciary, or the judiciary wasn't allowed to test them. So JR was not allowed. But after this time period, the court has said that it can test or it can review it judicially. So this is wrong and this is correct. Now let's move on to question number option 3. It can review its own decisions and orders. Yes, absolutely, because it is court of record and it can do such things. Now the expression judicial review is expressly used in constitution. No, it's used nowhere. It's just an innovation of the judiciary. So we arrive at option 2 only. Now going on to question number 59. The constitution provides several safeguards to ensure the independence of judiciary. Yes, even we can see in DPSP Article 50, which says that we need to have the states has to put efforts to separate executive from judiciary. Okay, the salaries and allowances of judges are charged on consolidated fund and are not subjected to vote in parliament. That's actually correct. The conduct of judge can be discussed freely in parliament except in motion for his arrival, for his removal. Actually, they have interchanged the words. Here it should be can't. If here we make it can't, then the statement would be right. But the main thing is to ensure separation of powers. The constitution has held that the parliament or any MP cannot discuss on the conduct of the judge unless there is a motion for his removal, because that is also stated in Article 121 and for the parliament, and Article 211 for the state legislatures to ensure the judicial independence. Moving on to the last question of the day, it's question 60. Arrange the following features by the year they were introduced first. Separate electorate for Muslims, we know Council Acts 1909. Association, it's 1909. Association for Indians with Executive Portfolio begins. Portfolio begins, it was 1861. Diarchy in the provinces, it was 1919 Act. Provincial autonomy was 1935. So it's 2, 1, 3, 4. Yes, that's right. Okay, that's all for today. In the next video, we will be covering from 61 to 100 question, and later on we will be doing economic questions. Or if you need, we will be continuing the polity as well. And if you wish, we will be doing them part by part. And we will be completing them in a proper sequence. I mean, first we'll be taking PYQs on preamble, then we'll be moving on to fundamental rights, then we'll be moving on to DPSP, then we'll be moving on to a union, then state legislatures and all. If you wish, let me know. We can do these kind of activities, or else we'll be continuing with economic questions, mainly for revision purposes only. So that's all for today. Thank you for your patience. See you soon.